Good morning. Today we're here for a presentation on the civility oath, is what it's referred to. What brings us here is the Supreme Court of California press release for immediate release on May 1st of 2014. Civility oath rule adopted by the Supreme Court will apply to new lawyers. And it goes on to state that the California Supreme Court today announced that it has adopted Rule 9.4 of the California Rules of Court to supplement the attorney oath for new lawyers. The oath will include a statement that the attorney will strive to conduct himself or herself with dignity, courtesy, and integrity. So that's what we're here to discuss today and give a presentation on this. Here's the actual oath as it stands today. It's the words that bar members who were sworn in prior to this date and have served in the state of California for a number of years would be familiar with the first part of this oath, which says, "I solemnly swear or affirm that I will support the Constitution of the United States and the Constitution of the state of California, and that I will faithfully discharge the duties of an attorney and counselor at law to the best of my knowledge and ability." Period. You're now sworn in as an attorney. Go forth and do justice, zealously defend your client, represent his or her case. But now we have the added language. Additionally, it now states every member of the bar, future member of the bar sworn in, will additionally swear or affirm as an officer of the court, I will strive to conduct myself at all times with dignity, courtesy, and integrity. So today we're looking at that language, the additional language. What does that mean to us as attorneys here in the state of California and our profession as a whole? So let's talk about a few of these words that are included in this. The first one is dignity. And here's just the dictionary definition of dignity. States a way of appearing or behaving that suggests seriousness and self-control, the quality of being worthy of honor or respect. So seriousness, self-control, behaving, quality of being worthy of honor or respect. The next word in the oath, dignity, courtesy. Courtesy, here's the definition of courtesy. Polite behavior, again talking about behavior that shows respect for other people, something that you do because it is polite, kind, etc. Something that you say to be polite, especially when you meet someone. But here comes the rub. The first two, dignity and courtesy, deal with our external appearance as attorneys, as counselors of law. How do we appear on the outside? Our behavior, how do we greet somebody, or do we do it with dignity and courtesy? But we also have this word integrity to deal with. Integrity is something in addition to, and here's the definition, the quality of being honest and fair, the state of being complete or whole, firm adherence to a code of especially moral or artistic values, incorruptibility, unimpaired conditions, soundness, the quality or state of being complete or undivided completeness. So integrity, while dignity and courtesy can have an external appearance to as we conduct our business as lawyers, integrity has to do with what's not necessarily so much on the outside, but what's on the inside and how that is reflected to the community and the public that we serve. So not only has the Supreme Court, as we're sworn in as new attorneys here in the oath of office, require us to externally exude characteristics that give confidence and honor and dignity and respect to the profession, but internally we need to have those character qualities of being honest and fair. So the background slides as we're looking, there is a reason for that. We have these pots, and pots as they're molded can look great on the outside here. If we go back to courtesy, beautiful pots look great on the outside, But really, when we come to integrity, we got to think about what is the structure. How was that pot formed? How was that pot formed? What foundation was laid for that pot? Because to be a pot of integrity means structural integrity. And you can look real pretty on the outside, but like this cup of coffee, when you put something hot in that pot, if the pot has cracks and wasn't formed with a good foundation of integrity, the pot's going to leak. Now, I've been informed that from ancient pottery makers, when they would make pots, some of the pots would have cracks in them, but they still want to sell their pots. So you fill the cracks with wax and you make it look really pretty on the outside. And it looks great, but when you get that pot home and you put a hot something in that pot and it heats up, guess what? The wax melts and it doesn't do what its function is, its intent was, which is to hold the water because it has the cracks. So speaking of this idea of integrity, structural integrity, it's really something that we need to consider in the foundations of our, you're an entering law student. You need to think about, well, I'm going to have to, ultimately, I want to pass the bar, I want to be able to swear that oath, but you have to lay the proper foundation. There has to be structural integrity in your foundation of learning law, the purpose of it, and the purpose of being a lawyer. So we really need to analyze that, and that's what we'd like to do today in this presentation. What is our structural integrity, and are we exercising dignity and courtesy in our profession as we enter our professional lives? So in doing that, they're talking about being an attorney of civility and really integrating these things into our professional lives, and as law students preparing to enter the field, exhibiting these things of dignity and courtesy and having this internal structural integrity, we need to think about several areas. One is having a good reputation. You can speak to attorneys in the field, and that's really the value of an attorney is really based on what their reputation is. You can speak to anybody in the field, oh, that attorney is well respected because of their reputation. That's the go-to person for that issue. So that's our currency, so to speak, in the legal profession, is our reputation. We need to talk about mission. What is our mission? We need to understand what our mission is in what we do as attorneys. We need to understand that and think about that as in law students, as we're laying the foundation to come to take this oath, and as practicing attorneys. We need to understand our mission and be able to successfully complete it. Professionalism. Sure, we need to have a discussion about professionalism in this. Our profession is routinely bashed for not having good ethics or professionalism. We need to have that discussion, and we need to implement that in the legal profession and continue to do so. Serving the client, we need to talk about that. What are we doing in serving the client? Because that's part of our core mission is, and ultimately we want to serve the client that is hiring us or whatever we're doing in our position. Zealous representation. Being an attorney of civility doesn't mean we roll over and give everything away. No, to the contrary. If you're being an excellent attorney, you're going to zealously represent your client's position. So we'll talk about that. Honesty and candor, of course, we need that, and we'll discuss that further, and then finish with this idea of this golden platinum rule. How are we to treat others? What's our standard? So speaking about each of these, one a quote: "A good name is more desirable than great riches." And what's significant about that quote is who it comes from. King Solomon, probably one of the wealthiest persons to ever live, is saying that, hey, having those riches is fine, but you know what's more desirable? It's a good name, it's a good reputation. That's really our currency as attorneys. So something to think about in laying that foundation as a law student. What is your reputation that you're developing as a law student and in our careers as in the legal profession? What is our reputation? Because that's really worth far more than silver and gold, It is our currency. It is our lifeblood in our businesses and everything that we do. So what's our mission? It comes straight from the California Attorney Oath. And what it says is to faithfully discharge the duties of an attorney and counselor at law to the best of my knowledge and ability. So duties of an attorney and counselor at law, okay, law students, you're studying in law school, you're learning all about that. That's a large body of learning. And it's something that you continue to learn. We don't end our learning careers at the end when we take this oath of office. No, you continue to learn throughout your careers, and that's great news. It keeps us young, it keeps us learning. It's important to continue to learn. So the duties of an attorney and counselor at law is something you will continue to do throughout your careers. The word faithfully discharging that. It's not giving it a half effort. That means a full effort. We are going to faithfully discharge these duties. We're giving it the 100% effort. And that's our mission as counselor of laws, to the best of my knowledge and ability, which we'll come back to. We'll talk to that in a bit. Professionalism, moving on to professionalism, this idea of being a professional. The quote where this comes from is from Brady v. Maryland case in 1963, which explained the criminal prosecution's duty to be fair in criminal trials. In order to be fair, you have to disclose evidence that's exonerating to the defense as well as all the guilty evidence, but we need to disclose that. We're required to have fair trials in this. And the quote from Brady is, society wins not only when the guilty are convicted, but when criminal trials are fair. Our system administration of justice suffers when any accused is treated unfairly. We need to keep that balance because it's so tempting, back to our original quote of the good reputation. It's better to have a good reputation than gold or silver. Well, it's better to have a good reputation than a guilty verdict as well. We can be tempted by, let's get the guilty verdict, let's get the successful resolution of this arbitration, let's get our civil suit in our favor with a big award. That feels great, but if we don't do it the right way, we compromise the administration of justice. We compromise our mission. We compromise our professionalism. So something to think about as we continue to lay that foundation of integrity. And here's the rules of professional conduct that attorneys can be disciplined for under professionalism, and it is failing to act competently, not living up to that faithful standard, faithfully administering the duties of an attorney. So, and in summary, the underlined portions, a member shall not fail to perform legal services with competence. And then it goes on. What does that mean? What does competence mean? It means diligence, learning and skill, mental, emotional, and physical ability reasonably necessary for the performance of such services. We can talk about each one of those. Diligence, you're going to be diligent. You're going to study that area of law so that you can be competent in that area, or your client is compromised if you aren't. That's why you're subject to discipline if you're not diligent. You have to get the learning and skill necessary in that specific area of law. Law today is an area of specialty. You have to know that specialty area that you're entering into to be competent. And the last part, probably one of the biggest ones that impacts the bar today, is mental, emotional, physical ability is compromised somehow. Well, how is that? Because we're having personal problems, we have personal issues, our own personal issues that interfere with the appropriate representation of our client because we're having family problems, whatever it is. So those outside influences need to be in check so that we can competently serve our client. So things to think about along those lines. And the last part is interesting side note about this idea of specialization, where it says that we can be competent to serve in a certain area even if we haven't worked in that area, if we associate or consult or acquire this knowledge to do that. So the bottom line here, it's good to get help. It's good to get help. An old saying says, in an abundance of counselors, there is victory. So don't hesitate to get outside counsel, somebody who's specified in that area, then you can be confident. You can meet that standard that we're required to. Now we need to take a break and have a little pig philosophy here with our discussion of professionalism. And the eternal question arises, why do you never wrestle with a pig? Why do you think? Why do you think? Well, I mean, you can look at the picture and you would say, well, you know what? I don't want to wrestle with that pig because obviously the pig's in the mud. What happens when you roll in the mud? You get dirty, right? Okay. So, well, what am I talking about here? Well, we're talking about maybe some of the attorneys haven't taken the civility oath yet. Well, they haven't actually, right? Now, I'm not saying that there aren't members of the bar that they act civil, courteous, they follow all of this, and hopefully we all do without even taking the oath is the point. But you are. I'm just breaking, newsflash, you're going to run across attorneys who don't act so civil. They want to fight with you in inappropriate ways. Hey, all for a good fight. That's what we do. And yeah, we'll battle it out, but we're going to do it the right way. But there's going to be folks who don't want to do it the right way. And you know what? They want to drag you down in the mud. They're kind of acting like the pig here in our picture. But we need to answer the question to help us so we don't get in that situation. Well, what do we do? Because it's very tempting to punch the pig back, right? To fight with the pig. We want to do that. But there's a big reason why we don't, and this is what we need to remember to hold our professional standards high, is you get dirty, right? You never wrestle with a pig. Number one, you get dirty. But there's a bigger reason why you never wrestle with a pig. And that's really what should motivate us not to wrestle with a pig. Because why? The pig likes it. That's the whole pig strategy. Draw you into the fight, draw you into the mud. You now have lowered your standards. You're no longer acting as an attorney of civility. You're fighting with the pig in the mud. And you know what that ultimately distracts from? Your client. Your client loses in the end because you're not an effective advocate. You're off wrestling with the other attorney in the mud instead of zealously representing your client. So, side note, little pig philosophy helps us, but it helps us move on to the next thing, which is serving our client, serving the client. And how are we going to do that with civility and serving that? And we're very good at understanding the problems and understanding the issues. We went through all of law school. You need to identify the issues. That's how you get your points on the exam, right? And then you give your legal analysis, and that's the bulk of your points. We don't care so much about the conclusion, but it's really your legal analysis what we're training you. And you hear it over and over. We're training you to think like lawyers. We don't care about the conclusion. We're training you to think like lawyers. And it's really true. We want to break down that analytical process so that you can recognize the issues for your client, the legal issues, and the problems. The problem with that, or not so much the problem, but the next step progression we need to take from that is, okay, we have a great legal base, we understand the problems, but we need to understand their problems and their issues, which might not fit in our neat little box of this is the issue, this is the rule, and this is the legal answer for your problem. And how do we get to the point of understanding their specific problems? Well, we need to take a walk in their shoes. We need to understand what our clients are going through. Hey, it's tough that we can't pay the bills. It's tough that they're charged with this offense and they're dealing with these struggles of life or whatever issue they're being sued for this, they're being sued for that, or they're facing custody time. We need to take a walk in their shoes, understand their issues, and that will help us serve the client and be this attorney of civility that we want in implementing this oath. So, in saying that, we need to zealously represent their issues. This quote from Berger v. U.S. that back in 1935 deals with a prosecutor in a prosecution case, but it applies across the board to attorneys. And it is this, that we may prosecute our case or serve that interest with earnestness and vigor. Indeed, we should do so. he or she should do so, using every legitimate means to bring about a just conviction or a just result for your client. We should zealously represent our client's interests. And the Supreme Court recognizes that in this context, the prosecutor, but the bar rules, what we're mandated to do to keep client confidences, everything we do as attorneys, we are to zealously represent the interests of the client. So a great thing to remember that being an attorney of civility doesn't mean we don't zealously represent our client's interests. On the contrary, we're mandated to, we're required to. So with that, honesty and candor, and this is taken right from the rules of professional conduct and trial conduct in California. So when we are presenting a matter to a tribunal, to the court, the member shall employ such means only as are consistent with the truth. You better remember that. You better employ means that are only consistent with the truth. Now, are there oftentimes two reasonable interpretations of the evidence? Absolutely, and we're going to zealously represent our client's interests in that. We're not saying that, but the means that you employ shall only be consistent with the truth. Additionally, we shall not use any artifice or false statement of fact or law. Shall not intentionally misquote the language of a statute or decision. And then D, shall not, knowing of its invalidity, cite as authority a decision that has been overruled or statute that has been repealed or declared unconstitutional. Interesting little extra language there, knowing of its invalidity. So if we make a mistake and we're citing an authority that, oops, we didn't catch it, it was overruled, technically not in violation of the rule, but when we find out later after we made that argument that it was overruled, we better be back in there in court and correcting that and letting the judge know, Your Honor, I made a mistake. I quoted an authority that I did not realize had been overruled, which your opposing counsel, hopefully if they're on it, they'll point that out to you at the time. But if they don't, hey, it's our affirmative duty to go and correct that record. And lastly, shall not assert personal knowledge of the facts at issue, except when testifying as a witness. Certainly if we're testifying, we're asserting that's true. But like in closing argument, we're not asserting personal knowledge of the facts. We are arguing based on the evidence that's been presented. As a prosecutor, for example, we're not saying, I believe that this is what happened in the case, because that's implying that I have inside knowledge outside of the body of the evidence in the case. And finally, this idea of the golden or platinum rule. So the golden rule, treat others the way you'd like to be treated. And this idea of the platinum rule is that not only the way you'd like to be treated, but how would they like to be treated? And it ties back into our kind of walking in their shoes. We have to understand our client, what the perspective they've come from. If we treat them the way we'd like to be treated, well, maybe that's not the way they want to be treated. Let's take a walk in their shoes. Let's understand their issues, and let's treat them the way they'd like to be treated, and let's treat others with dignity, courtesy, and integrity. So in summary, we've talked about these things of having this idea of dignity, courtesy, and integrity. Dignity and courtesy being the externals of how behaviors that we exhibit to the outside world. Integrity, though, something that happens inside. So we need to lay that foundation throughout our life. And in law schools, law students are entering into law school, laying that foundation of integrity, honesty, fairness, justice. And the areas where we do that is developing that good reputation, knowing our mission. You're going to understand it and learn it. Let's be competent in our area of practice. Professionalism. We're not going to wrestle with pigs. We're going to serve our client by knowing their issues, not just necessarily the legal black letter law issues, but their issues. And we're going to zealously represent their interests. With zeal, with fire in our bellies, we're going to represent their interests. And we're going to do it with honesty and candor, of course. And again, we're going to treat others the way we'd like to be treated, but also the way they'd like to be treated. With dignity, courtesy, and integrity. And that concludes our presentation. Thanks for your attention.